Hello, good morning, great people. It's Friday. Thank God it's Friday. Friday is always so exciting. Do I look like a ghost? Okay, I think I look fine. You guys can see me. There's not too much reflection. I'm so excited to be here. Today, we're going to be talking about prosecutorial discretion. So, if you have your case currently in immigration court or you're facing removal or what is popularly known as deportation proceedings, then we have some fantastic news for you. Yeah, my throat got dry pretty quickly, but um okay, so this is really fabulous news. DHS ICE, they released a memo a couple of weeks ago, and I have been reviewing this memo. Unfortunately, I haven't had time until now to do a live video on it, and we're going to be going through what prosecutorial discretion is. If you're currently facing deportation or removal proceedings, you're very welcome. If you're new to this channel, or if you've seen this channel, please subscribe and give us a thumbs up, comments, like, and we'll be very grateful. Okay, so what is prosecutorial discretion? So pretty much the point of all of this is that apparently there's 1.5 million cases pending in immigration courts around the US. And as you guys know, there's less than about 80 immigration courts throughout the US. And so that means that the courts are excessively backlogged. And so they've come up with a strategy that look, all the people that are facing removal proceedings or are currently in immigration courts facing or awaiting their deportation or going through proceedings to see whether they need to be deported or whatever other relief applies to them. If their cases are not on the priority list that we're going to discuss, there are three top priority lists. They are going to enjoy something known as prosecutorial discretion once they apply for it. And that will help them and give them end to the nightmare in immigration courts. Okay. So, what is prosecutorial discretion? What is prosecutorial discretion? So, prosecutorial discretion is actually a long-standing authority of law enforcement agency, and where they decide where to focus their resources and whether or how to enforce law against an individual. So, we know that ICE, which is immigration and customs enforcement, they are responsible for adjudicating, enforcing the nation's immigration laws. And they have issued a memo. So ICE's Office of the Principal Legal Advisor, that's OPLA, they issued a memo saying that since they have the statutory rights to exercise prosecutorial discretion for certain people, they are actually going to start to exercise that discretion in the litigation of removal cases. So this concerns people who are in removal cases, who are currently facing deportation, as we said. So they are now OPLA, that is the Office of Principal Legal Advisor of ICE. They are now going to focus their resources on the cases which are a threat to national security and a whole other list of priorities. So let's go through that. Before we even go into the memo itself, how does prosecutorial discretion work? Let's talk a little bit about how it works. So the OPLA attorneys, they'll independently evaluate your case, okay, and they'll determine whether to exercise prosecutorial discretion or not. So sometimes your attorney, well, for me, I certainly recommend that if you're in removal proceedings, because it's a big thing, you should work with an attorney, and then you submit the request on you submit a request to ICE or to DHS or to the government about receiving prosecutorial discretion. Of course, highlighting why you deserve it and the totality of the circumstances. Okay, so the people who are going to receive it are people who who have non-priority cases. Okay, so now let me share my screen and let's get into what are these priority cases, and then you can see if your case falls within the priority cases. And so if your case again falls within the priority cases, then it may be hard for you to receive prosecutorial discretion. But if not, then most likely you could get prosecutorial discretion for your case. So that's really good news. So Yes, so the goal of prosecutorial discretion as a tool is to preserve the limited government resources and achieve just and fair outcomes. Now, let me just scroll through to the bottom. I don't think we need all of this, the introductory. I've given a background. So, okay, good. Right here, we're going to be jumping into it. You know, the areas to be enforced. Okay, so the first thing is this. OPLA attorneys are directed to focus efforts and prioritize cases involving non-citizens who pose a threat to our national security, public safety, or border security. Okay, so the first one is the first people who are going to be prioritized. This means that the government is going to focus its resources on prosecuting the cases of these people who are in immigration courts. Number one, if you are a threat to national security. Who is a threat to national security? Somebody who's engaged in or suspected of terrorism, espionage, terrorism related or espionage related activities, or who otherwise pose a danger to national security. You are a priority for apprehension and removal. So if you're such a person, then you will most likely not enjoy prosecutorial discretion. Okay, then the second people are people who are persons who are threats to public safety. So we have priority A, then we have priority B. Priority A, topmost priority. Then we have priority B. So these things are being prioritized. So we have priority A, priority B, priority C, and then people who are non-priorities. Okay. So who falls within the category of priority B? So if you are in removal proceedings, or you're currently you're currently in immigration court facing deportation proceedings, then you are a threat to national security. I'm sorry, a threat to public safety. We are done with national security. Then you're going to become the target, or more or less, they're going to focus their resources on prosecuting your case. Okay, so a non-citizen who poses a current threat to public safety, typically because of a serious criminal conduct, you're a priority for apprehension and removal. So, for example, if you commit murder, and you're an immigrant, clearly you are a threat to public safety. Okay, so you cannot receive prosecutorial discretion, of course, based on the totality of the circumstances. So whether a non-citizen poses a threat to public safety is not to be determined according to bright lines or categories. Instead, it requires an assessment of the individual and the totality of the facts and circumstances. As I keep telling you, a lot of the times, law, the facts of people cannot be analyzed in vacuum. It should be contextualized. Okay, so even if you've committed something like murder, what led to the commission of murder? Perhaps it was self-defense. So they'll look at the totality of the circumstances. It was self-defense. Maybe you were heavily pregnant. Maybe you have such a clean record. So all these things will be looked at. What have you contributed to your community? What type of person are you? So it's not a bright line or category. It's not. There's no red and white. It's a totality of the circumstances situation. So even if you find that your case, your circumstances form part of the priority list, make sure you consult with an attorney, because sometimes there could be arguments that they could make to help you highlight factors that actually mitigate the priority factors. Okay, let's continue. So the third persons whose cases are going to be prioritized and who may not benefit from the latest prosecutorial discretion, if you are currently facing removal from immigration court, is persons who are a threat to border security. So who are these persons? So these are non-citizens, again, of course, not US citizens. You could be a green card holder and still face deportation proceedings. You could be a non-lawful permanent resident and then face it, of course. So a non-citizen who poses a threat to border security is a priority for apprehension and removal. A non-citizen is a threat to border security if they are apprehended. So if you're apprehended at the border or port of entry while you're attempting to unlawfully enter the US, or B, you were apprehended after unlawfully entering the US, after November 1st, 2020, then you are a threat to border security. You see, what they're trying to do is, imagine people outside here, there's currently prosecutorial discretion being granted to people in removal proceedings. they will find that, okay, it's an encouragement to come into the US unlawfully, and then even if they're taken to court, they'll get prosecutorial discretion. What the US government is trying to do is to make sure that they are not encouraging an influx of unlawful migration into the US. So this is going to curtail or sort of act as a disincentive for persons who hear about this prosecutorial discretion and feel like, okay, yeah, we're going to take advantage of it. So if you try to unlawfully enter the US after November 1st, 2020, then you are a threat to border security and you cannot enjoy prosecutorial discretion. Okay. Okay, so these are the top priorities. Now let's construing the three enforcement priorities. So we're going to look at, I hope we have a little bit more time. I've read this, as you guys can see, I've highlighted the relevant portion so that it's quite easy to just discuss them with you, and you have all the juice and the legal tea. Okay, perfect. So what's the priority A, a threat to national security? So in assessing whether a non-citizen is a threat to national security, the OPLA attorneys, they are going to consider a few things, and they must consider all available information indicating that the non-citizen is engaged or is suspected of terrorism or espionage. So you are either engaged in, or there's a suspicion of your engagement in these things, or you're either engaged in or suspected to be engaged in terrorism related or espionage related activities, or you otherwise pose a danger to national security. You see, sometimes US immigration laws, they actually, when it comes to things that will, let's say, criminalize you, they actually formulate the laws very broadly so that whatever you do, you'll be caught within the net. If it's a law that kind of gives an immigration benefit, then it's formulated very narrowly so that very few people can benefit from it. So you see how they've couched it. You are either engaged in terrorism or espionage, or in terrorism related or espionage related activities. So sometimes you realize that the person may, not be found in terrorism, may not be found engaged in terrorism, but they will interpret their act as terrorism related. So if the terrorism doesn't catch you, the related will catch you in a terrorism related activity. And this certainly can be broadly interpreted. So please be careful with whatever you do. So for purposes of national security enforcement, the terms terrorism or espionage should be applied consistently with the definitions of terrorist activity in sections 212 A3B II of the INA, and the manner in which espionage is generally applied in immigration laws. Okay, so we won't go into terrorist. Everybody knows who a terrorist is. Everybody knows who a spy or espionage, what that is. So when determining whether a non-citizen otherwise poses a danger to national security, OPLA attorneys should include in the determination process whether the non-citizen is engaging or suspected of serious human rights violation. Okay, so yes, that's going to be one of the assessments. If you're suspected or you're engaged in serious human rights violations, clearly that's not going to help you. So the values of our nation as a place of refuge for those who are fleeing persecution do not support providing a safe haven for people who have voluntarily participated in persecuting people or in the persecution or other human rights violations. So even when you're applying for citizenship, they ask you, have you persecuted anybody? Because they don't want to. So you may be fleeing, you may be coming as a refugee, but you've persecuted people. So he who comes to equity must come with clean hands. You cannot be persecuting people and expect protection from the US government. That will be very contradictory with the values of the United States, as we're seeing in the memo. Okay, so priority B, who's a threat to public safety? Let's take a look at that. Let me pull this up very nicely. Okay, so who's a threat to public safety? So whether a non-citizen poses a current threat to public safety generally turns on the seriousness of a non-citizen's criminal conduct and an assessment of the individual and the totality of the facts and circumstances. Okay, as I told you guys, what is the conduct of the person? So if you're a threat to public safety, for example, you went to Walmart and started slapping, you already, let's say you're in, you went to Walmart and you started slapping people, and then you were arrested, you're an immigrant, and then you are currently deportation proceedings. That's just a rough example, right? They'll look at the seriousness. Okay, how serious is somebody slapping, and then somebody who has killed somebody. Clearly the person who's slapping, that's not too serious of a criminal conduct. It's serious, but not too serious as compared to murder or rape or torturing someone or whatever. So they'll look again at the totality of the circumstances. If, for example, that day you were anxious and maybe something had happened to you and you can explain, and they look at who you are, whether you have a family, do you contribute meaningfully to society, do you volunteer, all the things that you do, and then they'll see whether it looks like this person is truly a threat to public safety or is not a threat to public safety. So in analyzing whether you're priority B, they are going to assess whether you're truly a threat, looking at the totality of your circumstances. Okay. So not all factors need to be weighed equally, as you guys know. Importantly, an individual's convictions or prosecutions, they're not the only things to indicate whether you are a threat to national safety. There's somebody who could be convicted or prosecuted, right? Said, okay, you've been convicted of, let's say, armed robbery. That's not the only thing. There are some people that may not have been arrested, but they are even more dangerous than people that have been arrested and convicted. So all these things, they're going to assess these things, and then they will determine whether you're truly a priority B and you're a threat to public safety. Okay, so relatedly, the existence of a criminal history alone, regardless of severity, will not necessarily indicate that a non-citizen presently poses a current public safety threat. Pursuant to the secretary's priorities. Okay, so there we're going to talk about aggravating factors, and we'll talk about mitigating factors. Aggravating factors are factors that will worsen your case. Mitigating factors are factors that will lessen or give you more favor before ICE, okay, or before the immigration court. So aggravating factors, or things that will make your case worse, they'll look at the gravity of your offense, of the offense of conviction. They'll look at the length and the nature of the sentence imposed. Then they'll look at the nature and degree of the harm caused to the victim or the community by the criminal offense. Then they'll look at the sophistication of the criminal offense, use or threatened use of a firearm, dangerous weapon, a serious prior criminal record. So, for example, some offenses are not sophisticated at all. Like if, for example, you went to a store and you saw a $5 note on the, let's say, a gas station, the store, you were buying chips, you saw a $5 note, you knew that note wasn't yours, and then you took that money. That's stealing, right? You can be arrested. As opposed to somebody that comes into the gas station masked up and holding a gun, all hands up, give me the safe key or whatever, and then takes $200,000 or $50,000. If you look at the two of them, clearly the person who picked up the $5 note, yes, they have committed a crime, but it's not as serious as somebody who came in with the intention to actually commit robbery. Okay, so that's these things are aggravating factors. If you hold a gun, like weapons, how dangerous the crime is, your prior criminal record and all of that. Mitigating factors, the mitigating factors are, okay, lengthy presence in the US. That will help you if you've been in the US for, let's say, 10 years, 20 years, very helpful, or whatever length of time. Even if it's 5 years, it's still, they want to look at how long you've been in the US. Then a mental condition that may have contributed to the criminal conduct, or physical or mental condition requiring care or treatment. As for example, as I was telling you, if you are anxious and maybe you have a history of bipolar or schizophrenia, and during the time it wasn't your lucid movement and you went around slapping people, it could be a mitigating factor, because that they can not justify, but they can explain why you acted the way you acted. Alrighty, let's continue. So some of the other mitigating factors could also be your status as a victim of crime or victim, witness, or party in legal proceedings, including relating to human trafficking and labor exploitation. Okay. Okay, yeah, let's move on. There's a lot of things we need to cover. Please drop me your comments and your questions if you have them, and I will do my best to answer you. Either, if you're watching live or if you watch later, yes, drop your questions and your comments. Okay, let me see what's this. The impact. Okay, yes, that's a good one. The impact of removal on family in the United States, such as loss of provider or caregiver, whether the non-citizen may be eligible for humanitarian protection or other immigration benefits. So, yes, for example, if you're a father in a home or you're a mother and you're the caregiver, you have three minors. Clearly, that's a mitigating factor because they don't want to deport you and then have your children here with nobody to take care of them. Of course, the Department of the child services could help, but nobody takes care of a child better than their mother, right? So all these things will be considered. Um, Other aggravating factors. Let's talk about some more factors that could aggravate your situation. Whether the non-citizen victimized a child or other vulnerable person as part of their criminal activity. Yes, look, if you get children involved in your criminal activity, that's the worst. You're in big trouble. If you killed a child, you raped a child, or you raped, people who are vulnerable or who are children. Big problem. That's an aggravating factor. It makes your case worse. Whether any criminal activity involved violence or was of a sexual nature, whether criminal conduct was in furtherance of the activities of a criminal street gang, all these things worsen your situation. But other mitigating factors are whether a non-citizen is pregnant. Again, that's a good one. If you're heavily pregnant and you go slapping, maybe you were in labor while you were in Walmart, you were pushing your cart, and then you started feeling the contractions and you were just slapping, because you were in labor, the contractions were coming. Okay, that's sort of like a mitigating factor. If you're pregnant, if you're going through postpartum. Okay, postpartum is after you've given birth, or if you're nursing maybe a 2-year-old, a 1-year-old, a 6-month-old, a 3-month-old, you will it's a mitigating factor. It helps your case. It helps you to it helps that ICE will deprioritize your case because this is a mitigating factor. Okay. Yeah, we won't go through. Oh, okay, now let's go to threat to border security. Let me scroll down. It's quite it's a 17-page document, but hopefully we should be able to cover the major parts of this. Okay. Yeah, right here. Yeah, I think we discussed this already. If in addition to people who surreptitiously enter, let me see, what does it say? So if you enter the US after November 1st, 2020, as well as if you are apprehended by DHS in the US, if you unlawfully entered the US subsequent to that date. Okay, so I must have skipped something. Let me just go back a little bit, maybe one or two lines. So it says that directly to non-citizens who are apprehended at the border or port of entry while they are attempting to enter unlawfully or enter after November 1st, as well as non-citizens who unlawfully entered after that date. Okay. Subsequent to that date. Okay, that's fine. Okay, I think we got that. Okay, so we're right here. So you again in this context should be okay. Who apply for if you that's a threat to border security. So you're going to be arrested and then you're not going to be enjoying prosecutorial discretion. So such compelling factors. So the Mayorkas memo further explains that this priority category could apply to other border security cases that presents compelling facts warranting enforcement actions. So these compelling factors, if you're knowingly involved in the smuggling of non-citizens, smuggling means you're bringing somebody in violation of US laws, bringing them into the US when they don't have the proper visas or permission to be here, regardless of whether they have been charged with smuggling offenses, particularly when available information indicates that the smuggled non-citizens were abused or mistreated. These are compelling facts that will warrant enforcement action. if you're smuggling people and raping them, abusing, mistreating them, very, very dangerous situation. This category could also include those who engage in serious immigration benefits fraud that threaten the integrity of the immigration system. Examples of these things are if you include fraud as criminally prosecuted, and then if you knowingly enter into a marriage for the purposes of evading immigration laws. These things are compelling facts that warrant enforcement action. Okay, so please be careful with these things, because if this is your these are your facts, then you may not benefit from the prosecutorial discretion. Again, just make sure you see an attorney. They'll review the totality of your circumstances and then tell you, what you can, how you can benefit. So, exercising prosecutorial discretion. OPLA attorneys must be particularly mindful of the resources. Okay, so we spoke about this. Immigration courts docket total over 1.5 million cases nationwide. So they have to soundly prioritize the litigation efforts through the appropriate use of prosecutorial discretion to preserve limited government resources and achieve just and fair outcomes in individual cases. Okay, good. So this is something I want to talk about. Normally, the attorneys, the OPLA attorneys, as the ICE attorneys, they're expected to exercise discretion at all stages of the enforcement process, but in court. But what they're saying is that the exercise decisions to exercise prosecutorial discretion, it should be made at a very early stage, because the whole point is to preserve and conserve resources. So there's no point prosecuting the person for 3 years and at the end you let them go. At the beginning, immediately you see the ICE attorney see this is not a priority case, they should not even bother to issue an NTA, notice to appear, or even bother to send people to court, or even start a master's and an individual hearing and all of that. They should dismiss it where they can, and at the earliest. So the point is the earliest moment practicable. When? So this addresses at what point in time must the government attorneys exercise prosecutorial discretion as early as possible, as early as possible, as early as possible. In evaluating late emergent requests and unrepresented non-citizens, pro se status should be taken into account. So if you are unrepresented, you don't have an attorney, they'll take your case. As much as you don't want to go into immigration court without an attorney and have the government decide for you. So priority cases. So non-citizens determined not to be priorities for enforcement may receive prosecutorial discretion. Yay! Of prosecutorial discretion. I hope you guys can still see me. Let me pull this up. Okay, so let's talk about how these non-priority cases are handled. When we talk about you receiving prosecutorial discretion, although you are in immigration court, there are various ways, and the preferred forms of prosecutorial discretions are they will not file an NTA, and as I said, an NTA, I believe it's 862 from 862. That's the notice to appear, the formal documents that charges you, gives you the charge, and tells you to appear in immigration court at a particular date and at a particular time, and then again it stipulates your charge, right? They will not even bother to file an NTA in your case. If the NTA has already been filed, then they'll dismiss your proceedings. This is amazing, okay? OPLA attorneys may, in appropriate cases, consider alternative forms of prosecutorial discretion, including administrative closure. So administrative closure, if your case is administratively closed, it means that they temporarily terminate your proceedings so that you go and seek relief elsewhere. So for example, if you are in court and then you get married to a US citizen, or, for example, they could administratively close your case so that you go and pursue adjustment of status where viable with USCIS, which is an affirmative form of relief. It's not a defensive form in court. So that's administrative closure. Then stipulations to issues or relief. When they stipulate to issues, means that they do not counter it. They agree to what issues your version of the issues that you're stating, and then they'll also give continuances. Sometimes they'll continue. When your case is in continuance, they'll also allow you to go and seek relief elsewhere and try to adjust your status. They'll put a hold on the court proceedings so that you can get relief somewhere. And if that works, you come back and let them know, hey, this has worked. And then they can terminate. Not pursuing an appeal, right? So if you've you have been granted a relief, then the government attorney should not appeal and say, no, 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 don't grant this person this relief, right? Just let things go. Like, we don't have enough resources, attorneys, like government attorneys. So they are being advised, don't pursue appeals. Just be mindful of these things, because all these things take resources and drag cases out in immigration court. And then they should join motions to reopen. So remember that motions to reopen can be opposed by government attorneys. So they can sometimes file an opposition if you do a motion to reopen. For example, if you've been ordered removed in absentia, and then you file a motion to reopen to actually rescind the past immigration order, and then reopen your removal proceedings based on some good reason, that maybe you didn't receive the notice to appear or whatever, then DHS can either, when the DHS joins the motion, it means that the motion will be granted. Once the DHS is not opposing it, normally the immigration judge will grant the motion. But once DHS opposes it, then it's going to be a tussle back and forth, and that may not be granted. So they're telling the government attorneys, just join motions to reopen, just allow the people to reopen their motions, so that there's no back and forth and waste of resources and stipulations and bond hearings. But OPLA's strong preference is to efficiently remove non-priority cases from the docket altogether, to best focus enforcement resources on departmental priority cases. So again, working with an attorney will be able to highlight these things according to statutes, according to the memo, to ensure that, if your case, even if you're on the borderline, we're able to push to make sure that, you can enjoy prosecutorial discretion. It's very important. Okay, so when a legalist notice to appear, yeah, I won't go into that. I don't think that's necessary for our purposes. I know I highlighted it, but yeah, dismissal proceedings. So for people who are unrepresented, those who do not have lawyers, if you are not parties for enforcement, as early in the process as possible, that's ICE or OPLA attorneys, they should advise the immigration judge that this case is not is a non-priority, and that they should also talk about the fact that they believe dismissal is appropriate, and OPLA will agree to a continuance to allow the non-citizen to seek counsel, to seek a lawyer, and consider whether to agree to dismissal. Okay, so all these things, please, you certainly want to make sure you have an attorney with you if you're facing deportation proceedings, so that they can ensure that your case is dismissed in immigration court. Okay, administrative closure, I believe I spoke about that, by taking the case off the immigration court's active calendars, but it does little to permanently address the surging growth. Okay, so yes, so OPLA strongly prefers dismissal of proceedings as a discretionary tool in non-priority cases. Okay, yes, we will not go into too many of that. Stipulations and issues, no. Let me see if I highlighted any other thing. Okay. Oh my goodness. Yes. Have we run a marathon? Oh boy, oh boy. Okay. So I hope you guys have benefited from this video today. There's prosecutorial discretion if you're currently you're currently facing removal proceedings in immigration court. I'm actually located in Northern Virginia. My name is Attorney AK, and my law firm represents immigrants throughout the US. And if you need help, especially, I'm very close to the Arlington Immigration Court. And of course, so I practice, I practice all 50 states. But if you're specifically in the DMV area, Virginia, Maryland, and DC, please feel free to contact us, and we will do our very best to assist you in your removal case, to make sure that you get the help that you need. Okay, so if you want to call us, that's our number right there. Please don't forget to subscribe and like our page. I will see you guys soon in my next video. Thank you so much for watching. I really appreciate it. We have Huri, who says, thank you for the live. You're very welcome. TPS holders with approved spousal came back with I-131 parole. Can I adjust status in the US? And the removal already? I need prosecutorial discretion. Okay, please call our offices and then schedule an appointment and let's talk. Let me review everything before I can give you an answer. A lot of the times it just really depends on what is at play, how you came in, what's just happening in your case. Okay, so please contact us and we'll be able to assist you. I will see you guys later. Take care and thank you for watching. Bye bye.